In the case of In re Federal Water Service Corporation, we'll see how a dispute over a corporation's reorganization plan ultimately led to not one, but two United States Supreme Court cases. In 1937, the Federal Water Service Corporation filed an application with the Securities and Exchange Commission, or S.E.C., for a corporate reorganization. Chenery Corporation owned a controlling stake in Federal Water. While Federal Water was working with the S.E.C. on its reorganization plan, Chenery began legally buying additional shares of Federal Water's stock. The S.E.C. held that it would approve Federal Water's reorganization plan if Chenery sold its newly acquired stock. The S.E.C. based its findings on common law principles such as equity, as well as property law principles. The S.E.C. held that corporations can't buy their own stock during a reorganization because this violates a company's fiduciary obligation to its shareholders. Chenery challenged the S.E.C.'s decision, and the case eventually went to the United States Supreme Court. In this case, referred to as Chenery 1, the Supreme Court held that even though the S.E.C.'s outcome was correct, the legal basis it used to require Chenery to sell its stock was flawed. The court couldn't substitute its own rationale to support the S.E.C.'s holding, so the court remanded the case back to the S.E.C.